It may kindly be
is invoked.
that has been set aside. COCA was invoked. It has been set aside by this honorable court. So what we have in the entire charge sheet is, my lords, only statement of co-accused. My lords,
Yes.
what they find is there was an assembly of persons near judicial layout, and on getting information, they go there and these four of them run up, four are apprehended. They find certain weapons in the car. And
On whose statement are you bought in?
on the statement of A1 and A2. Other than that statement, my lords,
Corroborative material?
nothing. Absolutely nothing. 402, assembling for purpose of committing dacoity. So 402 is ruled out, my lords. So only we come down to 399, which is preparation, where there's evidence against co-accused sufficient, if believable, to support his conviction. Then the kind of confession described in section 30 may be thrown into the scale as an additional reason for believing that evidence. Court would say you can't proceed only on the basis of a co-accused statement, and that is in a case of a 302, my lords.
This has become final?
Yes, my lords.
Yes, my lord.
What was the date of preparation according to you? 20th February 2017.
Yes, my
He was in police custody in the same police station up to 21st February 2017. A day later.
Yes.
Where is the preparation in the police station? 399 and 402 preparation
Yes.
and assembly. Execution. He was in the police station.
Enforcement of charge sheet, my lords. Offences, major offences 399 and 402.
Where did you commit dacoity?
Preparation, my lords. Preparation, no dacoity committed. Preparation, 402, they should have assembled there. But it does not attract in this case, my lords. Could I just point out, my lords, the list of date may kindly be...
COCA is invoked.
That has been set aside. COCA was invoked. It has been set aside by this honorable court. So what we have in the entire charge sheet is, my lords, only statement of co-accused. My lords,
You are accused number 12.
now I am accused number 11.
11. Yes.
My lords, I get arrested in this crime number 42 of 2017, my lords. That was on 8/2/2007.
Who is the complainant?
It is a sumoto complaint.
The inspector. only.
Yes, my lords. What they find is there was an assembly of persons near judicial layout, and on getting information, they go there and these four of them run up, four are apprehended. They find certain weapons in the car, and that's why 399. But at that point of time, I'm in custody. Kindly notice, my lords, in that synopsis list of dates, when I go to custody, 8/2/2017, the very first date, my lords. 8/2/2017, petitioner, he gets arrested, my lords, and remanded to police custody for a period of 14 days in crime number 42 of 2017. My lords, in that case, in the FIR, offences were 341, 504, 506, read with 34. In the first case. Now, my lords, on 20th at 3 a.m., my lords, respondent number 2 registers a sumoto case in crime number 58 for offences punishable under section 399, 402, and under section 27 and 30 of the Arms Act against 8 named and others. Now, the allegation there, my lords, of what has happened, my lords would see at page 4, the first paragraph at page 4. They just get information, my lords, that certain people are sitting in a car at 3 a.m. and they go to the spot. As soon as the police comes to the car, some of them run away, 4 of them are apprehended, certain recovery is done. This is the basis on which the sumoto complaint gets done.
On whose statement are you bought in?
On the statement of A1 and A2. Other than that statement, my lords,
Corroborative material?
nothing. Absolutely nothing. And my lords, 402, I should have been there as an assembly. If 402 is
Yes.
seen, my lords, to attract 402, my presence in the spot would be mandatory. Read. My lords, 402, assembling for purpose of committing dacoity. So 402 is ruled out, my lords. So only we come down to 399, which is preparation. And for preparation, my lords, the only reliance they place is a statement of 2 co-accused, A1 and A2. And no act committed, my lords, because it was only an attempt or preparation, my lords. That's how the case reads. Now, my lords, in a case of this nature, where the entire charge sheet material is only based on a co-accused statement, the law on the point is on the basis of 2 rulings of the Supreme Court, my lords. The one is Surendra Kumar Khanna versus Intelligence Officer, my lords. This is in 2018, 8 SCC, page 271. Could I just pass?
What is volume 1 and 2 here?
The papers, my lords, are the entire charge sheet material. And also the order of this court insofar as invocation of COCA, which was set aside. My lords, in this, the relevant portion is paragraphs 10 to 12. Even a constitution bench ruling has been quoted there, my lords. Paragraph 10, it starts with Kashmira Singh, my lords.
Next judgment.
Paragraph 10, they quote Kashmira Singh, my lords, that it is virtually in the nature of only a corroborative material, not a substantive piece of evidence, Kashmira Singh. And at paragraph 11, my lords, constitution bench, in the case of Hari Charan Kumar Kurmi versus State of Bihar. Could I just read that portion at paragraph, which is extracted as para 12, my lords? My lords, that's from Hari Charan Kurmi. As we have already indicated, this question has been considered on several occasions by judicial decisions, and it has been consistently held that a confession cannot be treated as evidence, which is substantive evidence against a co-accused person. In dealing with a criminal case, where the prosecution relies upon the confession of one accused person against another accused person, the proper approach to adopt is to consider the other evidence against such accused person. And if the said evidence appears to be satisfactory and the court is inclined to hold that the said evidence may sustain the charge framed against the said accused person, the court turns to the confession with a view to assure itself that the conclusion which is indicated to draw from the other evidence is right. As was observed in so and so, a confession can only be used to lend assurance to other evidence against a co-accused. In so and so, it was observed the provisions of section 30 goes not further than this, where there is evidence against co-accused sufficient, if believable, to support his conviction, then the kind of confession described in section 30 may be thrown into the scale as an additional reason for believing that evidence. So, my lords, again they quote Pumoni Sahu. It's a very weak type of evidence, my lords. That's what they call out. And finally, my lords, on the paragraph 12, the law so laid down has always been followed by this court, except in cases where there's a specific provision in law making such confession of co-accused admissible. Because, my lords, in certain acts like COCA, we can use it, my lords, but not under the IPC. So, my lords, following this in Deepak by Jagdish Patel, the Supreme Court, my lords. Again, they follow the very same aspect at paragraph 24 of that judgment, my lords. There, even for framing charge, it is not sufficient, is how the court would hold. My lords, at paragraph 24, the previous judgments are quoted.
That's the only paragraph?
Yes, my lords, that's the only paragraph which they deal with it, and they say even they couldn't have framed charges. That's how the court goes about it, and would virtually discharge him. And the aspect of discharge there, my lords, the relevant paragraph on discharge.
Yes.
Sorry, all the later paragraphs are all on discharge, my lords, after that.
Yes.
And then, my lords, quite recently, my lords, in a 302 case, a coordinate bench had an occasion to see, can you only rely on the co-accused statement? They say no, and they quash the proceedings. My lords, this is in Srinivasa alias Kulla Sina versus State of Karnataka, 10th July 2023. My lords, the judgments which we relied on in that case.
All extracted here.
Yes, my lords, it's at page 5, and then paragraph 20, my lords, the court would say, you can't proceed only on the basis of a co-accused statement. And that is in a case of a 302, my lords.
This has become final?
Yes, my lords, it's become final. But now, my lords, in our case, 399 and 402. 402 doesn't attract at all. 399 is preparation, my lords. That's all the case is about.
My lord, I'll take instructions in this matter, my lord. But upon this accused, my lord, this petitioner, there are 11 cases. He is involved in different offences, my lord.
Maybe.
And
No, he
11
may be
cases are-
involved in different offenses.
Yes,
What
madam.
about the subject crime?
they were
Proceed against him in anything else?
preparing for the Decoity with a pistol and other weapons, my lord.
Correct.
Yes, my lord.
What was the date of preparation according to you? 20th February 2017.
Yes, my lord.
He was in police custody in the same police station up to 21st February 2017. A day later.
Yes,
Where is the preparation in the police station?
but not this
So where
accused,
then-
my lord, not this accused. They are.
ಬೇರೆ accused
gang, my
ಮಾಡಿರ್ಬೋದು.
lord.
Based on those statements, you have tracked this accused inside.
Yes, my lord.
If there are many other accused, many other crimes against him, proceed.
All are involved in the
ಇಲ್ಲ, ಆಯ್ತು, involvement ಇದೆ.
type of dacoity, my lord.
399, 402 preparation
Yes.
and assembly, execution. He was in the police station.
Yes, my lord. In the police station, but on the basis of
Police
the voluntary
custody ಇದೆ.
statement of the co-accused. my
True,
lord,
he was in police custody on that day. 399, 402 ಏನ್ ಬೇಕು?
But he is also involved in other different crimes, my lord.
ಆಯ್ತು, different crimes ಇರಿ, different proceedings ಮಾಡಿ.
Can I clarify on that, my lords? Page 429 ಅಲ್ಲಿ court here, while quashing coca proceedings,
Page.
page 429, volume 3, my lords. When coca proceedings have been quashed.
Ah.
I put a table, my lords, the cases against the present petitioner, 429. My lords should get it at accused number 11, petitioner, kindly notice.
429.
429, my lords.
Yes.
429.
The
Additionally,
charge-
accused number 11, Rohit Kumar petitioner, kindly notice, my lords, 3 cases, 2 cases acquitted, 1 case quashed. The only case against him is the present case now.
I'll take clear instructions, my lord.
Order ಇದೆ sir. What clear instructions? ಆಮೇಲೆ ಅದಕ್ಕೆ you should be ready reading the files. Yes, anything?